see where we go. Okay, a foreign asset protection trust is set up in an offshore jurisdiction which has enabling trust legislation providing for substantial protection against creditors of the trust. The greatest advantage, not one of, but the greatest advantage of the Foreign Asset Protection Trust is the fact that by its very nature, any legal attack against its assets are transferred abroad to a different legal system. The foreign trustee is necessary for the efficacy of the Foreign Asset Protection Trust. There can also be a U.S. trustee or a U.S. Agent, and that would reduce some of the reporting requirements if you have that. Most of our clients elect not to do that. They elect just to have the foreign trustee and go ahead and file the extra documentation with the IRS. The biggest advantage is, again, that the assets are placed offshore beyond the jurisdiction of the U.S. courts. You can have a duress clause and you can price the assets offshore, but I don't set the trust up normally unless there's already assets offshore. And it's so difficult to set up a bank account that you've got to do it in advance. And so if you're going to set it up in advance, you're going to need some liquidity to set it up. And the bank isn't going to be too excited if it's a $50,000 deposit. So I found that it has to be a lot larger than that. Okay, most foreign jurisdictions do not recognize U.S. judgments. This may force a new trial on the merits in the foreign side of the country. So, for example, let's say that the creditor gets a judgment against you in the United States and they try to go against the offshore trust. They're going to have a trial de novo. That means they're going to have to have the witnesses and everything else over there. Some foreign side jurisdictions require a much more difficult burden of proof for a creditor. I told you that before yesterday. The Cook Islands, for example, has a criminal burden of our criminal burden of proof for civil matters, and that's written into their code. Some jurisdictions have a statute of limitations. The Cook Islands has a 2-year statute. Fees and expenses in litigating in the foreign jurisdictions are going to be substantial. Thereby, they serve as a strong deterrent. It takes the teeth out of a fraudulent conveyance charge because of the difficulty of the creditor to proceed against the transferee. It prevents attachment against the transferred asset. It makes any type of an injunction against further disposition of assets extremely unlikely because the court can't get jurisdiction. It practically eliminates the appointment of a receiver over the transferred assets, and it places the assets in a jurisdiction whose laws are favorable to debtors and hostile to creditors. An offshore trust with at least one U.S. beneficiary is a grantor trust. As a result, the Foreign Asset Protection Trust is a pass-through entity to the grantor, similar to a revocable trust. So even though it's and it's got to have the grantor powers that are necessary to make it a grantor trust. It's not a completed gift. And it is included, the assets are included for estate tax purposes in the estate of the client. The transfers through a Foreign Asset Protection Trust are incompleted gifts, and they are included in the, and then we talk about the office of a trust protector. The protector, again, has the power to remove the trustee and appoint a substitute trustee, and that's very, very important because the trustee may begin to charge more fees, or it may change, or there could be something happen. It can change the status of the trust, and many times the protector can be an entity or a person not subject to the jurisdiction of the U.S. court. And there's a duress provision, which means that any time that there is a court order forcing that comes into the trust to the trustee can either change the jurisdiction. In most instances, and the trustee can substitute itself out, and you automatically and appoint another trustee.